Hello viewers, I'm Ron Grant coming to you live and direct from Tortola in the Virgin Islands. You're watching 284 Media. Thank you so much for your time. The highly controversial police bill, also known as the Police Act 2023, is back, and there is an attempt to pass this bill in one sitting. Now, the Police Bill 2023 essentially seeks to remove the involvement of the courts as it relates to obtaining biometric information, searching of private property, and seizure of property. Throughout the bill, we see the term reasonable grounds. This term is treated in law and as an objective test. In other words, what an ordinary person would think if they had all the information that a police officer had. Now, in practice, viewers, there is a great degree of subjectivity given the difficulty and expense in litigating against the government and in particular the police, especially in terms of evidential hurdles and arguments such as opening the floodgates. There is effectively very little an ordinary citizen can do to battle unreasonable use of police powers. Now, in obtaining warrants, the police are tasked with information the court of what their reasonable grounds are for the access, seizure to of property and biometric information. Now, the court's task is to consider whether such grounds are reasonable. By largely eliminating the need for warrants, this protection of the public is totally removed. This bill, if becomes legislation, effectively turns the Virgin Islands into a police state. I am today joined by attorney at law and member of the BVI Bar Association, Mr. Daniel Davies, to discuss a number of key areas of great concerns to the citizens of the Virgin Islands. Now, the police bill does not stipulate how evidence is to be handled, which can lead to abuse of such as planting of evidence and such as intimate samples. We're going to take a direct look at this Police Bill 2023 when we return after a quick commercial break.
Is someone going to get that?
Hello.
Hello. So nice of you to have cleaned up for us. Hi, baby.
We're like in-laws that don't show up unannounced.
Don't worry. I've got this.
CG Insurance. Good like that.
Catch Super Bowl 57 on CCT Live. Sign up today by calling 444-4444.
Catch the game on CCT Live. To sign up, go to cctbvi.com or call center at 444-4444.
Is that my lunch? Is that my lunch?
We're like the coworker that doesn't eat your lunch.
I'm John. I'm John.
CG Insurance. Good like that.
Welcome back, everyone, and thank you so much for sticking with us. As promised, I am joined by attorney at law Daniel Davies, who is also a member of the BVI Bar Association. We are going to be tackling the highly controversial Police Bill 2023. Attorney Davies, thank you so much for your time and welcome back to our studios.
Oh, thank you for having me, Ron. It's always a pleasure to be here.
Likewise. Now, as mentioned in the introduction, this bill is being attempted to be passed within one sitting, and there are a number of concerns, not only now, but the first time that it was brought up to the community, where citizens and persons like yourself within the legal profession have questioned. Let's begin with section 27 to 35. This particularly, viewers, allows the police to obtain without consent a person's fingerprint, foot impressions, etc., without a warrant. Now, while DNA testing is essential in the solving of cases, this particular bill, DNA and intimate samples may be taken without a warrant, but without consent. When we look at section 27 to 35, as an attorney at law, what are some of your great concerns, and what do you think persons within the community should be paying special attention to?
Well, just so that you're aware, I think you misspoke when you said without consent.
Okay.
DNA samples and intimate samples must be taken with consent. However, the fundamental issue that arises is that if you do not wish to give your DNA, that or intimate samples. And just so the audience knows what intimate samples means, it means semen,
Yes.
pee, and that sort of thing. And if you don't provide that DNA upon or intimate sample upon request, it can be held against you essentially in court, because what the section says is that if you fail to give these samples upon request without a good cause, then the court or the jury can draw whatever inferences they wish from it, including negative inferences.
Okay. Now, when we look specifically at these circumstances, what are your thoughts in this method being utilized?
Well, it's quite scary because, firstly, we have a constitution. We have a constitutional right to privacy, and if you're not charged with anything, if you're not convicted of anything, that is to say, you're acquitted of something, or if the prosecution decides they're not going to continue with the case, then why should your DNA or your biometric information like fingerprints, which can be, by the way, taken without a warrant and without consent, or footprints and so on and so forth, why should they remain on a government database?
Okay, and don't you think that in some cases a government database is essentially important in solving cases across the board?
It may be, but so is our constitutional right to privacy. You see, in the UK, they have something called net rights, which is essentially what you're left with after the legislature and the government take everything else away. Now, in the Virgin Islands, as you know, we are quite American-leaning, and so the layperson views their rights essentially as absolute. They interpreted their rights in the American way. So the question is, what is the point in having constitutional rights if the legislature can, at a drop of a hat, just limit your rights and take previously enjoyed benefits of your rights away?
Understood. Is there anything else, particularly between sections 27 to 35, that is of concern to you?
Yes, the obtaining of biometric information without someone's consent and without a warrant. That is a bit scary. And yes, I understand that there is a necessity to solve crimes in the territory, but there's also the necessity to ensure a person's rights and privacy are protected.
Understood. Now, when we look, Attorney Davies, at Section 36, this allows for the police to search people in their dwellings without a warrant. Tell us about that.
Yes, so essentially what the police are allowed to do, will be allowed to do, is that if you are arrested on an arrestable offence, which could be murder, but it's oftentimes not as serious as murder. It could be a theft, because theft is triable either way, meaning it can be tried in the magistrate's court, which is the summary level, or it can be tried in the High Court as an indictable offence. So indictable offences are also arrestable, also known as arrestable offences. So they have you, they can go to your house or your premises and they can search the property. Now, the question is, the concern is that you don't even have to be charged. You just have to be arrested. Charges come after the arrest. Correct. So you don't have to be even charged with anything. So that is a serious concern.
Is, in addition to this, particularly when you look at the fact that police are or could be allowed with the passing of this bill to search people's dwelling without a warrant if they have reasonable grounds or for believing that a person does not live there or does not have permission to the ground. We mentioned in the introduction where this, and you could perhaps tell me if you agree or not, does this now not open the door for persons being tarnished, evidence being planted in that manner?
That is a grave concern that members of the criminal bar have expressed to me. That is a very real possibility. Now, you see, it's critical to understand that what this bill is based upon.
Okay.
This bill is based upon something known as the Police and Criminal Evidence Act in the United Kingdom. However, this is a standalone bill, or a standalone piece of legislation. In the United Kingdom, right, they have all sorts of different codes of practice that are publicly available, that the public has access to, can view, and so these codes of practice are the things that, or the procedures and regulations that the police must abide by.
Okay.
And so there are a multitude of things that the police have to abide by pursuant to those codes of practice that do not pertain to this legislation because, as is usual, we don't really, unless something is going to be a nuisance to a person, meaning we only really pass regulations providing that they can be a nuisance to people.
Okay.
And the Virgin Islands is how things go, unfortunately.
All
Yes.
right. Now let's continue. When we look at Section 38, we also, this is quite similar to 36, but Section 38 specifically says it allows a police officer to search someone's home who is arrested on an arrestable offense without a warrant, even without that person. We're continuing on to, of course, Section 42 at this point. Allow the police to access communications between lawyer and client. Legal privilege is a constitutional right, as we know, enjoyed by every individual that provides that. How are we now getting into this point with this particular bill that even client privilege, confidentiality will be at risk?
Okay, so what the legislation says is that, well, the proposed legislation says is that you must present it in a sealed form to the police officer who requests it. Now, that just means essentially in an envelope or maybe in a sealed envelope, but it's very easy to open a seal,
Correct.
And not to cast any aspersions on the police, but like criminals, they specialize in crime. And so the question is, would it be easy to open it, look at its contents, and then put it back in as if no one has actually ever seen it, when in fact they have seen it? And so that is a major concern. But back to Section 38, just one thing that popped into my mind is that if you are not there, if a person in your home is being searched by the police, suppose they go with something, suppose you end up missing something, how do you know that the police have gone with this particular item?
Understood.
So it could lead to cases where there's deprivation of property, which is, just so everyone knows, under the Constitution, you have a right to your property.
Understood. And going back to Section 42, as an attorney yourself, how does that impact attorney-client privilege?
Well,
and the protection of both parties?
Well, it impacts it because it essentially gets rid of it. Meaning to say, and what it encourages is for lawyers not to actually take any note of what their client actually said, because it may be revealed to the police, who may, for whatever reason, and their own reasons are, and the reasons are their own, I should say, be conducting an investigation into your client. And so that is a major issue. It is a constitutional right, by the way, legal privilege, and this piece of legislation is really, again, seeking to limit that constitutional right to keep what goes on between client and attorney between client and attorney. Now, I should say this. Legal privilege is that of the client, right? It is not to protect the lawyer.
Correct.
It exists only to protect the client, and so the client can waive legal privilege if the client wishes. And certain things are not privileged. So if the client was asking advice on how to commit fraud, that is not legally privileged information.
Okay.
But of course, if you're discussing your defenses to a possible action, or maybe civil action, could be criminal actions, possible defenses, then that is legally privileged information.
Understood. Thank you for that clarification. And now we go to Section 45, which allows the police commissioner to implement a cordon whenever he or she sees fit. Now, a cordon is much like a curfew, and the act will allow the commissioner, without any supervision or oversight, to limit movement or require people to stay on their premises during a certain hours. Of course, we saw this, Attorney Davies, in recent years with the COVID-19 stipulations that would have a curfew and try to keep persons safe. Section 45. What is of concern, particularly when it comes to this section?
Well, firstly, cordons occur. Police commissioners generally have a power to, issue cordon all over the world. But what frightens me and should alert the public, well, cause alarm among the public, is that it avoids a curfew order having to go to cabinet for approval, and so, and nothing within this legislation would limit the police commissioner from issuing one cordon after the other, or in other words, successive
Correct.
cordons. And, the curfew was hard enough as it is, but at least that had some sort of democratic process. This doesn't have any democratic process at all, because there's nothing which empowers even the governor to intervene.
Wow. Okay.
Or the cabinet for that matter, or the National Security Council. This is at the sole discretion of the police commissioner.
Understood. Now, Section 49, continuing, allows the police who are lawfully, of course, members of the police force on the premises of anyone to seize their property without a warrant, once again, and require access to their computer without a warrant, as is presently required. Now, currently, the Cybercrime and Computer Misuse Act requires the police to obtain a warrant from the court before requiring a person to give access to the police to their computers. Once again, if this act is passed, that right is removed.
Yes, so it's not really a right per se. So the warrant process allows the court to act as a counterbalance, arbiter, to ensure that the police aren't just on a fishing exercise.
Understood.
And that, because it's very easy to say, okay, it's very easy to say, to create grounds post factum, right? So if you're challenging court as to whether you had reasonable grounds, and then it's very easy to come up with some ground or other. In other words, what I'm saying is that suppose they didn't actually have any grounds before, but they found something on the property which gave them some belief that it may have been connected to something criminal. Or it could be that they never actually suspected it in the first place, don't suspect it afterwards, but want to retain your property for whatever reason, and just say, well, we believe that this is connected to this or that. And so the way that warrants work now is that they would have to come up with the reasons for wanting to take a particular piece of property or to enter the premises before they actually do that.
Understood.
So it acts as a protection to stop them from coming up with excuses afterwards. Now, the seizing of the property, this can only be done if it is necessary for the purposes, well, if the the investigating officer or the policewoman believes that if they don't take it, the evidence could be damaged, altered, or concealed. But again, what is necessary in the mind of a police officer will differ. There's no objective standard.
Understood.
Even if you do, things can be done on an objective standard, even on a case-by-case basis. But again, it's just very easy for the police to come up with many different excuses as to why they thought it was necessary.
After the fact. Understood. Now, as we continue on, viewers, sections 186 to 189 allows for the altering to the right of silence and allows the court to draw negative interferences from a person exercising their right to silence. Currently, no negative interferences can be drawn from a person wishing to remain silent. The right to silence is a constitutional right. So once again, we are seeing where in this bill, let's take myself for an example. I choose to not say anything. Not only is it being held against me, but in the court, jurors have the ability to draw a negative interference from the fact that I've chosen not to say anything?
Inference.
Yes.
Yes, inference. Yes, the right to silence is a fundamental right because it protects people from self-incrimination. And one must remember that most people don't know what the law actually is. The police have a much better idea of what the law is, and so you may indeed say something during an interview that you think is perfectly innocent. And it turns out, well, it may have indeed constituted an offense, and you would have incriminated yourself. And is that a position that anybody really wants to be in? Secondly, you could be forced to disclose what your defense is before, but based on this section,
Yes.
you may be essentially forced to disclose what your defense is, and allow the police to close certain gaps before. How do I say this in a very civil way? Without assigning any aspersions to the police, it may allow them to do certain things to ensure that you can't effectively raise that defense.
Okay.
Even if the defense is in fact a genuine defense.
Understood.
And one of the things that you probably know, having lived here your entire life, being raised here, is that unfortunately the Virgin Islands does not have enough trust in the police.
Correct.
For something with as far-reaching and
magnitude, yeah.
and of this magnitude to be passed, because this Police Act really limits your rights, your constitutional rights, in a very severe way, and there must be some modicum of trust, but there isn't any. Nobody trusts the police in the Virgin Islands to have, well, some people do, but hardly any. And there's even distrust amongst the police force itself.
Correct.
And so the question is, do you want to give a single institution such as this much power, given the level of distrust?
You're absolutely right.
And as I was saying before, what is the point in having right included in your constitution when the legislature or by extension the executive can at a drop of a hat drop of a pin, just decide, oh well, these things should be limited or taken away. What is the point? And the reason why I said executive is because you have to understand what the numbers are in the House of Assembly.
Yes.
You have 7 ministers essentially, 5 cabinet level, 2 junior levels,
yeah.
but that's still government. The government, there's 13 members in the House of Assembly. That's over half of the House of Assembly. So the government can take away essentially your constitutional rights or limit them in such a way that they're pretty much non-existent. And it's something that that's a bridge that we have to cross.
When are we going to cross this bridge? As we mentioned, there is an attempt to pass this bill within one sitting, and we've done the job for you viewers. Of course, the act itself is quite lengthy. It is a public document that you can access, but we've narrowed it down to a number of sections that are of great concern. Attorney Davies, what can the public do, having been privy to this information moving forward?
I think they need to lobby there. We need to lobby our politicians. We need to lobby the governor to say this is not something that we want in the Virgin Islands. But there is one point that I forgot to raise.
Sure.
So one of the fundamental differences between the legislation in the United Kingdom, there are two major differences actually, between the legislation as it exists in the United Kingdom and the legislation in the Virgin Islands. The legislation in the United Kingdom does not restrict somebody's rights to silence. Right? And they also say at section 78, I believe, of the Police and Criminal Proceedings Act, the Police and Criminal Evidence Act in the United Kingdom, that unfair evidence may, at the discretion of the court essentially, be excluded from trial. What that means is that a piece of evidence may indeed be relevant to the trial and to the proceedings, but because of the way it was obtained,
Correct. It becomes inadmissible.
it becomes inadmissible. In the Virgin Islands, this legislation that we have here, it doesn't have that protection for the public. In fact, it says essentially that even illegally or obtained evidence, well, that's true of the Evidence Act as well, but even evidence that is obtained not following the procedures as set out in the Police Act may be admissible or is admissible in court.
Understood.
And so what ramifications will the police have for breaching your rights? What ramifications will the police have for, as against abusing their authority in terms of, obtaining certain things, like fingerprints not in accordance with the legislation? There are no ramifications. And so if there's no ramifications and the incentive is a conviction, well, they have all the incentive in the world not to follow the legislation.
While the human rights of citizens are abused.
While the human rights of citizens are, and not just citizens, everyone in the Virgin Islands.
Understood.
I don't see this necessarily as something that's solely affecting belongers. It's affecting
Not at all.
everyone in the
Not at
Virgin
all.
Islands. And one of the fundamental issues is that I think is quite concerning, and I know we're running out of time, but I have to bring this out, is that part of the legislation requires that, allows the police to search someone at their dwelling without a warrant in circumstances where the police has reasonable grounds to believe that you shouldn't be there, you don't live there. So, we have a lot of very big houses here, and we have a lot of police persons that are, policemen and policewomen that aren't from the Virgin Islands, and some of them aren't from the region, and so they see someone dressed up in clothes that they believe to be raggy, and a very expensive house or even a car, because to a certain extent a car can be considered under certain legislation premises, but let's say they see a fairly ragbaggy looking old fellow in the yard of a very expensive home. According to that policeman, this might be a vagrant, and so they will have reasonable grounds per se for searching this person without a warrant and without any other reasonable suspicion. And I don't think that is something that is acceptable in the Virgin Islands.
And I definitely have to agree with you, Attorney Davies. Now, you mentioned about citizens lobbying essentially to lawmakers and the executive for change in this. But I also want to ask you, you are a member of the Bar Association here in the British Virgin Islands. From a legal fraternity perspective, what else could be done in support of the lobbying?
Well, I'll be quite honest. While I am a member of the Bar Association, I don't represent their views.
That's correct.
And to be quite honest, I haven't paid my dues to them this year, so they'll be expecting that soon. But I don't know what can be done in terms of. I suppose you could write to the president of the Bar Association. And to be quite honest, I can't say I quite remember who that is myself. Perhaps I'm a bit lackadaisical with respect to certain things.
Titles, right?
Yeah, with respect to titles. But certainly lobbying the elected representatives and the governor. Because at the end of the day, while elected representatives, some of the elected representatives do sit on the National Security Council, the police falls squarely within the governor's portfolio.
Understood. Attorney Davies, you have been so gracious to come and bring to light many of these sections that are of great concern. But in the final analysis before we go, I'd like you to speak to the Virgin Islands community as it relates to how their lives, how all of our lives will essentially change if this police bill, also known as the Police Act 2023, is to be passed. How exactly will our lives change, and what should we be concerned about moving forward?
I would say that you would have very limited expectations of privacy should this legislation be passed. And it should be remembered that when the Police and Criminal Evidence Act was passed in the United Kingdom in the 1980s, that was also a very controversial bit of legislation, because they had the same concerns that we had about limiting of people's rights to privacy, inhuman and degrading treatment, deprivation of property. Because suppose the police take your property and they say that, oh, it's for an investigation. An investigation could go on for so many years, and what can you do to get back that property?
Yeah.
Very little.
Indeed. Citizens, we hope that you have been able to take away much from this presentation, giving you insight into the Police Act 2023 that is being attempted to pass within one sitting of the House of Assembly. Joining us, as I mentioned, was Attorney at Law Daniel Davies. For 284 Media, I'm Ron Grant. Have a beautiful rest of the day. Bye-bye.